We're going to shift in our discussion to a case that Matthew is directly involved in. When we continue, we're talking with Matthew Green. He's an attorney. His practice is devoted into civil litigation, emphasis on commercial litigation, professional liability, products liability, insurance coverage.
Radio.com. Radio.com.
We are in discussion with Matthew Green on our program. He is an attorney, and he's joined us for both hours of our program this Sunday morning. I'm Bob Salter. We move into a discussion now about a case that Matthew is directly involved in because he is the civil attorney for George Huguely. His last name, is it pronounced Huguely? Is that right, Matthew?
Huguely.
Huguely. Would you give us a little bit of the background on this case?
Absolutely. Well, some of your listeners may recall back in 2010, George Huguely, my client, and his on-again, off-again girlfriend at the time, Yardley Love, were both getting ready to graduate from the University of Virginia. They had both been varsity lacrosse players at UVA, wonderful scholarship athletes. And Yardley was found dead in her apartment just off the campus at the University of Virginia very early in the morning of May 3rd, 2010. George was charged with a number of offenses related to her death. He was ultimately convicted of second-degree murder, for which he is currently serving a 23-year sentence. And I'm now involved in the subsequent civil litigation. It's a wrongful death lawsuit brought by her estate against him for money damages.
All right. There's a number of questions in this case. When we talk about the idea of, we hear this term an awful lot, wrongful death, and again, from the standpoint of the layperson, we hear this term, it's talked about relatively quickly. What exactly is a wrongful death case? And in this case, what specifically is alleged?
Right. Well, Bob, wrongful death is just a subset of a personal injury case. I think most folks are familiar with that. Is basically, a car accident case would be your most classic example. Someone's in a car accident, they're hurt, and someone else was at fault, so they bring a lawsuit against them. A wrongful death case is really no different than that, with the exception of instead of the individual being hurt, the individual is actually killed. And so their estate, or their heirs, if you will, then bring a lawsuit on behalf of the estate in which they allege they're entitled to the monetary damages for the loss of the life, for the loss of their loved one. So that's all we mean about when we say a wrongful death suit. And in this particular case, Yardley was killed as a result of what happened on May 2nd and 3rd in 2010. And so her estate, in the person of her mother, Sharon Love, has filed a lawsuit alleging a number of things about George, but at its most basic, it alleges that he was negligent, which is a legal term. It essentially means there was an accident. He's responsible for that accident, and as a result, she's entitled, in this case, to $30 million in damages.
The exact cause of death, has that been determined? Was that ever determined?
Well, that is really one of the key issues in both the criminal case and now in the civil case that I have. I can tell you the physical injuries to her head and what the medical examiner concluded and what the medical examiner didn't conclude. But in essence, the medical examiner lists the cause of death as blunt force trauma, which is a medical term which basically means someone was whacked by something in some part of their body. And in this case, the force was applied to the head of Yardley Love. And the documented external injuries to her head were relatively limited. She had an abrasion, which is a scrape, to her right chin. She had a bruised and swollen right eye. And then she had a small amount of dry blood underneath her nose and her lip. And Those are the injuries that killed her. That's not really up for debate, or I should say that led to intercranial, a brain neurological bruising, very small on her brain that killed her. The question is how she got those injuries.
Well, when you say the question is, why is that a question? What's at the root of that?
Right. Well, the original media narrative, if you will, was that George had gone into her apartment, had beaten her head against the wall of her bedroom, and had left a very bloody crime scene, and that obviously if someone beats your head repeatedly against the wall, we all understand without being a medical examiner or a forensic pathologist that that's a means to kill someone. But the evidence that emerged is that media narrative is completely incorrect. There's absolutely no evidence that her head was beat against the wall. There was no damage to the wall itself. This was not a bloody crime scene. When her roommate came home approximately 2 hours after George left her apartment, there were no signs of an altercation in her bedroom. Her clothes remain neatly folded in her dresser. Her books remain neatly in place on her desk. The photographs on the wall of her bedroom remain neatly in place. The roommate suspected that it was alcohol poisoning. Yardley had been out consuming alcohol with her friend throughout the day. It was a weekend day in Charlottesville back there in May of 2010. The roommate suspected alcohol poisoning, called 911 with that report. The paramedics came. They attempted to resuscitate her, and they noted the physical injuries that I've described. And so we're left to piece together what exactly happened. There was not an eyewitness to this, but there was an ear witness to the encounter. The woman that lived in the apartment directly below Yardley's, who's now a medical doctor in Houston by the name of Anna Lehman, she heard George enter that apartment and heard him leave approximately 8 minutes later. And this was a relatively inexpensive apartment building with thin walls. She testified that she was able to hear loud conversations, yelling, screaming, things like that in the apartment above hers. But in this instance, she heard essentially nothing. She heard no yelling, no screaming. The one and only sound she did hear during that 8-minute encounter was what she described as a large and heavy bookcase falling to the ground and hitting the floor. And we believe that what happened was George and Yardley were on Yardley's bed having an emotional conversation, and something happened that caused the two of them to fall together off the bed onto the floor. And that's what the ear witness heard, and that during the fall, the 220-some pounds of George's body landed on the head of Yardley and caused the injuries that I've described. And in essence, that's the mechanism of injury, is how a lawyer would describe it, that describes those physical injuries that I've documented.
So you're saying it was an accident?
Absolutely. So really the mechanism of injury isn't as important as whether or not George's acts were intentional or whether they were accidental. And if they were accidental, he is not absolved of legal liability in this matter. He is still legally responsible for her death. And George would be the first to tell you that he is legally responsible for her death in both the criminal and the civil context. But it matters whether or not his actions were intentional. And based on the facts as we've discovered them in the civil litigation, I think the evidence strongly suggests they weren't intentional in any way.
George, what is he like, and how often do you see him?
I have the opportunity to see him about 3 or 4 times a year. He's a wonderful individual. He's extremely intelligent and articulate. He's now been serving in excess of 6 years. He's like I said, he has a 23-year sentence. George kind of got himself in a bit of a mess in college. Towards the end of it, he developed a severe binge drinking problem. At the time of this encounter with Yardley, he had consumed in the 30 hours before it probably about 30 alcoholic beverages. Unfortunately, this wasn't uncommon for him during his last year at the University of Virginia. But since then, you can call it forced sobriety if you want to, because he's incarcerated. But he's shooken the demon of alcohol that gets its claws on so many members of our society. And he has been a model inmate. I think anyone at his facility would tell you that. He's progressively worked his way down to a lower and lower security system within the Virginia Department of Corrections. You see all the intelligence, the charm. He's a good-looking individual, just a great physical specimen. He was obviously a varsity athlete in a Division I athletic program. So he's a real pleasure to represent for those reasons.
Well, he's 6 years into a 23-year sentence. Realistically, how much of that time would he actually wind up serving?
Well, he was convicted and incarcerated under the Virginia state system. The Virginia state system does not have parole. Parole was abolished in Virginia about 15 years ago. They do give you a limited credit if you serve your time without incident, without any kind of demerit or whatever term they use. And he's, like I said, been a model inmate. So realistically, he'll need to serve about 85 to 90% of his sentence, which would take, in his case, he would serve approximately 20 years.
And is he, this might seem silly to ask this, but I'll ask the question because I've talked on the air about this. I've had the opportunity where I've taught in prisons, done some college classes there, and been in situations with people who are incarcerated for lengthy periods of time in many cases. One of the things that struck me most during the time that I was teaching in the institutions where I was in New Jersey was that the men talked about their future. They talked about what they wanted to accomplish. In some cases, they talked about what they wanted to do when they got out of prison. And this is after serving lengthy sentences. And some of them were in there for life. Does he talk about that?
Yes, he does. And he, I'm a graduate of the University of Virginia as well, so I might be a little biased, but it really is an excellent institution. Graduates there are extremely intelligent, smart, driven individuals. And George, despite the mess he made of his life back in 2010, is really no exception to that general rule. I could very much see him being a paralegal or even going on to law school. He is deeply immersed in all of the legal angles in both his criminal and civil litigation. He reads all the Supreme Court cases that affect it, all the appellate level cases that will affect any issue in his litigation. And it's hard at his age, he's 28 now, to think about life in another 16 years because, when he gets out, he'll be approximately 43 years old, which is essentially my age. And I'll look at him and I'll say, George, I know you look at me and you think I'm an old man, but when you get out of here, you will be my age, and you can still get married, you can still have a family, and you can work as a productive member of society for, a 30-year career. And that's really starting to sink into him. He gets it. He doesn't underestimate how difficult another 14, 15 years behind bars will be. But if anyone's equipped based on a supportive family, a good educational background, and just natural ability, charm, and charisma to make the most of himself once he serves his time and gets out, it'll be George Huguely.
Radio.com.
We're talking with Matthew Green on our program. He's an attorney. He's the civil attorney for George Huguely, and in the wrongful death case that he's been talking with us about. Now, one of the things that I wanted to mention, too, is there's a website at truthforgeorge.com. Why was this established?
Well, very early on, Bob, in this case, for a number of reasons that some of which are explainable, some are not, there was a large amount of media attention. This was just heavily covered back in 2010 through the criminal trial of 2012, and I was even in Charlottesville on Friday for a hearing on this matter and walked out of the courtroom, and there were news cameras ready to roll, at least for local coverage within Virginia. And early on, within about 24 hours of the initial charges filed against my client, there was a media blackout. The Commonwealth's attorney elected to seal the entire, what would normally be the public record, elected to seal that and not allow the media to have access. So the media was heavily handicapped in reporting the allegations, the factual allegations against my client, and a lot of what emerged from that. And unfortunately, when that happens, there were a lot of mistruths, a lot of misinformation that got reported in the public. One report said that a bloody T-shirt had been found in his apartment. That is absolutely incorrect. This was not a bloody crime scene. One report said that George confessed to beating Yardley's head against the wall. He absolutely never made that confession, and in fact, his entire police interrogation video is available on YouTube. It's easy to find if people want to watch it, and I think they'll see if they do that he did not admit to beating her head against the wall. So this is just a chance for us to put out, for anyone that wants to see, truthforgeorge.com, exactly like it's spelled exactly like it sounds, and it just kind of lays out some of the basic facts so people can educate themselves about what actually happened.
This wrongful death case that you were involved in, how long is it anticipated this is going to proceed?
Well, the entire process, believe it or not, it's going to take about 2.5 years for a number of reasons that I won't bore your audience with. But it's allowed us a very long time to conduct what civil attorneys call civil discovery. And probably the most important mechanism of civil discovery is the civil deposition, where we can identify all the witnesses with relevant information. We can set a time aside, and attorneys for both sides in the litigation are there with a court reporter. The witness is sworn under oath, and we can ask questions relevant to this case. And it's an unbelievable tool that allows us to really understand and learn the important facts and learn what really happened on May 2nd and 3rd of 2010. We've done a lot of that. We've done 16 of these depositions to date with 16 different witnesses. We have a handful more to go, and it's now set to kick off. The civil trial will be over 3 weeks, beginning on March 6th of 2017 in the Circuit Court of the City of Charlottesville, Virginia.
Why is it that this case became national news?
Well, it had a lot of elements that appealed to people that I guess got eyeballs or clicks or however the media world defines it. But you have two extremely attractive individuals from very unique and privileged backgrounds. They're participating in a elite sport, lacrosse, that tends to attract individuals from a higher socioeconomic background. They're doing it at one of the nation's elite universities, the University of Virginia. And then you've got all the love angle of this was a girlfriend-boyfriend relationship with so, you know, those angles just attracted people. And it was unusual to find, extremely unusual to find a pretty young, talented individual like Yardley Love dead from blunt force injuries in her bedroom, and that's just going to be a lot of attention to it.
So it was labeled the lacrosse murder.
It was.
Right.
That had nothing to do with anything in her bedroom or her cause of death in any way. It's just that the two of them had been lacrosse players at UVA.
What's the legacy of this case?
The legacy of this case is that we really had the luxury now, 6 years after the event, to see how the facts are developed in two very different environments. And the first is a closed environment where the media and the public does not have access to the basic facts. and then misinformation comes out. It's no one's fault. It's not intentional, but this misinformation creates a very unique environment in which a criminal trial is then conducted and places great challenges on that particular court and how they have to deal with it. And I'm not suggesting that the court didn't handle it properly and appropriately. I think they did. But there's just a reality when a trial is conducted in that kind of intense media glare, as opposed to now we're redoing the trial a second time. It's a civil trial instead of a criminal trial, but the same facts are at play, and we're doing it in a much more prolonged way. We've had a lot more time to develop the facts. We've done it essentially out of the media glare as opposed to the first time, and we've been able to use these depositions I referenced to quietly and patiently learn what exactly happened. And I think you learn, and it's probably worthwhile to keep this in mind as we talk about something like the Stanford case that's currently in the media, that to learn what actually happened takes time, it takes patience, and it's worth doing that so that ultimately, whatever the case is and whatever the issue, we get the right result.
The U.S. Supreme Court in October of last year, if I read correctly, had turned down I guess it was it an appeal? Was that the motion?
Well, in essence, it's a petition for an appeal. It's a request that they take the appeal, and they turned that request down.
And why did they say they didn't?
Well, you have to keep in mind that the thousands and thousands of cases are appealed to the U.S. Supreme Court in the United States every year. Of those thousands, they take somewhere between 1 and 200. So almost all cases are turned down by the U.S. Supreme Court, and it really says nothing about that particular case other than it's not critically important legal issue that warrants time on the court's docket. But George had the benefits of due process. He was given a trial with competent attorneys in Virginia in the criminal justice system, and he was able to appeal that to the Virginia Supreme Court, and the Virginia appellate courts did hear that appeal. So he did have the normal mechanisms that's available to criminal defendants in this country.
Talking with Matthew Green on our program on the Fan this Sunday morning. He's an attorney. Now,